I'm reading from Torts, Cases and Materials by Prosser, Wade, and Schwartz, the 12th edition. I'm on page 356, which is chapter 6, Proximate or Legal Cause, and we're in the public policy section, which is part 3 of that chapter. And I'm going to read a case from the Supreme Court of New Jersey in 1984 titled Kelly v. Gwenel. Book brief. Defendant Gwenel, after having driven co-defendant Zach home, spent an hour or two at Zach's home before leaving to return to his own home. During that time, Gwenel consumed 2 or 3 drinks of scotch on the rocks with Zach and his wife. Later, Zach accompanied Gwenel outside to his car, chatted with him, and watched as Gwenel drove off to go home. On the way home, Gwenel was involved in a head-on collision with an automobile operated by plaintiff Marie Kelly, who was seriously injured. Kelly sued Gwenel and Gwenel's employer, and those defendants in turn sued Zach's in a third-party action. Thereafter, plaintiff amended her complaint to include the Zacks as direct defendants. The trial court granted the Zacks' motion for summary judgment, holding that, as a matter of law, a host is not liable for the negligence of an adult social guest who has become intoxicated at the host's home. The appellate court affirmed, noting that New Jersey has no Dram Shop Act imposing liability on the provider of alcoholic beverages, and that New Jersey common law liability had been extended to a social host only when the guest was a minor. Willens, C.J. This case raises that's the judge. This case raises the issue of whether a social host who enables an adult guest in his home to become drunk is liable to the victim of an automobile accident caused by the drunken driving of a guest. Here, the host served liquor to the guest beyond the point at which the guest was visibly intoxicated. We hold the host may be liable under certain circumstances. Negligence is tested by whether the reasonably prudent person at the time and place should recognize and foresee an unreasonable risk or likelihood of harm or danger to others. When negligent conduct creates such a risk, setting off foreseeable consequences that lead to plaintiff's injury, the conduct is deemed the proximate cause of the injury. A tortfeasor, this is a quote, is generally held answerable for the injuries which result in the ordinary course of events from his negligence, and it is generally sufficient if his negligent conduct was a substantial factor bringing about the injuries. I'm not even plugged in here. Okay. Under the facts here, defendant provided his guest with liquor, knowing that thereafter the guest would have to drive in order to get home. Viewing the facts most favorably to plaintiff, as we must, since the complaint was dismissed on a motion for summary judgment, one could reasonably conclude that the Zacks must have known that the provision of liquor was causing Gwenel to become drunk, yet they continued to serve him even though he was visibly intoxicated. By the time he left, Gwenel was in fact severely intoxicated. A reasonable person in Zach's position could foresee quite clearly that continued provision of alcohol to Gwenel was making it more likely that Gwenel would not be able to operate his car carefully. Zach could foresee that unless he stopped providing drinks to Gwenel, Gwenel was likely to injure someone as a result of the negligent operation of his car. The only question remaining is whether a duty exists to prevent such risk, or realistically, whether this court should impose such a duty. When a court determines that a duty exists and liability will be extended, it draws judicial lines based on fairness and policy. In a society where thousands of societal values is part of the analysis, thousands of deaths are caused each year by drunken drivers, where the damage caused by such deaths is regarded increasingly as intolerable, where liquor licensees are prohibited from serving intoxicated adults, and where long-standing criminal sanctions against drunken driving have recently been significantly strengthened to the point where the governor notes that they are regarded as the toughest in the nation. See Governor's annual message to the New Jersey State Legislature, January 10th, 1984. The imposition of such a duty by the judiciary seems both fair and fully in accord with the state's policy. So another point for the analysis is judicial intent. Okay, and safety was the first one of the society at large. We therefore expand our prior decisions that limited liability to licensees who served liquor for profit or social hosts who serve liquor at a minor to a minor, hold that a host who serves liquor to an adult social guest, knowing both that the guest is intoxicated and that he will thereafter be operating a motor vehicle, is liable for injuries inflicted on a third party as a result of the negligent operation of a motor vehicle by the adult guest when such negligence is caused by the intoxication. That's their holding. We impose this duty on the host to the third party because we believe that the policy considerations served by the imposition far outweigh those asserted in opposition. That means that this is kind of easily preventable. So they're going to hold the person responsible who had the easiest that could have prevented it easiestly. While we recognize the concern that our ruling will interfere with accepted standards of social behavior, will intrude on, somewhat diminish the enjoyment, relaxation, and camaraderie that accompany social gatherings at which alcohol is served, and that such gatherings and social relationships are not simply tangential benefits of a civilized society, but are regarded by many as important, we believe that the added assurance of just compensation to the victims of drunken driving, as well as the added deterrent effect of the rule on such driving, outweigh the importance to those other values. We therefore reverse the summary judgment in favor of defendant Zach and remand the case. So that's the conclusion. And next we have a dissenting opinion, which is from Garibaldi. The majority need not parade the horrors that have been caused by drunk drivers to convince me that there is always room for stricter measures against intoxicated drivers. I, too, am concerned for the injured victim of a drunk driver. However, the almost limitless implications of the majority's decision lead me to conclude that the legislature is better equipped to effectuate the goals of reducing injuries from drunk driving by protecting the interests of the injured party without placing such a great burden on the average citizen in the state. So they think that it's just like an unduly high burden for the host of the party. My reluctance to join the majority is not based on any exaggerated notion of judicial deterrence to the legislature. Rather, it is based on my belief that before this court plunges into this broad area of liability and imposes high duties of care on social hosts, it should carefully consider the ramifications of its actions. This court has in the past imposed civil liability on commercial licensees who serve alcoholic beverages to intoxicated patrons. Commercial licensees are subject to regulation by both the Alcoholic Beverage Commission ABC, and the legislature. It is reasonable to impose tort liability on licensees based on their violation of explicit statutes and regulations. I have no quarrel, so he's saying make it a criminal offense rather than a basis for tort liability. That would be more appropriate, is what he's thinking. Especially because in those cases where they are seeking civil compensatory damages, they can bring negligence per se case against the social host. I have no quarrel with the imposition of such liability because of the peculiar position occupied by the licensee. A social host, however, is in a different position. A significant difference between an average citizen and a commercial licensee is the average citizen's lack of knowledge and expertise in determining levels and degrees of intoxication. Licensed commercial providers, unlike the average citizen, deal with the alcohol-consuming public every day. This experience gives them some expertise with respect to intoxication that social hosts lack. A social host will find it more difficult to determine levels and degrees of intoxication. The nature of home entertaining compounds the social host's difficulty in determining whether a guest is obviously intoxicated before serving the next drink. In a commercial establishment, there is greater control over the liquor a bartender or waitress must serve the patron a drink. Not so in a home when entertaining a guest. At a social gathering, for example, guests frequently serve themselves, or guests may serve other guests. Normally, the host is, so this isn't like sole control over like instrumentality. So you could say that other factors could have contributed, the contributing causes as a defense. Not so in a home when entertaining a guest. At a social gathering, for example, guests frequently serve themselves or others. Normally, the host is so busy entertaining he does not have time to analyze the state of intoxication of the guests. Furthermore, the commercial bartender usually does not drink on the job. The social host often drinks with the guests, as the Zacks did here. And further, it is not clear from the court's opinion to what lengths the social host must go to avoid liability. So it's unclear standard of care. And is the host obligated to use physical force to restrain an intoxicated guest from drinking and then from driving, or is the host limited to delay and subterfuge tactics short of physical force? What is the result when the host tries to restrain the guest but fails? Is the host still liable? The majority opinion is silent on the extent to which we must police our guests. The most significant difference between the social host and the commercial licensee, however, is the social host's inability to spread the cost of liability. And the commercial establishment spreads the cost of insurance against liability among its customers. The social host must bear the entire cost alone. The social host may not have sufficient insurance to cover the limitless liability that the court seeks to impose, and these people may lose everything they own if they are found liable as negligent social hosts under the court's scheme. The individual economic cost to every New Jersey citizen should be weighed before today's result is reached. Now, this concludes the case. Now, reading notes and questions. The New Jersey legislature later modified the decision by statute to limit liability in several ways. Under the statute, liability of the social host extends only to third parties, for example, not the intoxicated person. There is an irrefutable presumption that anyone whose blood alcohol level tested at least at less than 10% was not visibly intoxicated, and a reputable presumption that anyone whose blood alcohol level between 10 and 15 was not 0.10 and 0.15 was not visibly intoxicated. I don't know these things. That's nice. So there's a reputable presumption. And the social host is not jointly and severally liable, which means the social host would pay only a portion of the judgment, even if the driver is insolvent. Got it. 2. In notes and questions, the traditional common law view was that the drinker's voluntary consumption and subsequent negligence was the sole proximate cause of the third party's injury, and that a person who sold or gave liquor to the intoxicated adult drinker was not liable for subsequent injuries caused by his intoxication. Okay. The seminal decision is Cruz versus Aiden. 1889, where a wife filed suit against her husband's friend for giving her husband 2 drinks while he was guest at a friend's house. While returning home on horseback, the husband was thrown from the horse and died. The Illinois Supreme Court refused to impose liability, finding no cause of action for giving a glass of intoxicating liquor to a friend as a mere act of courtesy and politeness. Illinois reaffirmed this decision, holding that for over 1 century this court has spoken with a single voice to the effect that no social host liability exists in Illinois. It's quite a bit of notes and questions. Gonna leave off at the top of page 360.